It'll take 20 minutes to slide and divide it up. All right, so we each got a certain amount of time.
Good morning. May it please the court. Jason Burnett on behalf of the appellant, R.J. Reynolds Tobacco Company. I would like to reserve 4 minutes of my time for rebuttal.
So out of 20, he's still taking 20, he's taking 20 for both cases. Well, actually, it's so big, I thought it was 2 cases, it's 1 case.
It's 1 case, Your Honor. That's correct. That's correct. So 20 minutes for each side. I'm taking
You
16.
can start the clock, I just want you to know that, this is a little chit chat. Are you ready? I'm gonna start the clock.
I'm ready, Your
All
Honor.
right.
Thank you. May it please the court. The Florida Supreme Court's decision in Prentice clarified what must be proven in an Engle progeny case to establish reliance. It must be reliance on a statement or statements. It cannot be mere silence or a failure to speak. There has to be evidence that the smoker received, believed, and acted on the information.
This came out while this appeal was pending, practice.
It came out before this appeal, so the decision came out after trial.
After trial, I should rephrase that question.
Correct. So the trial court's post-trial order addresses Prentice. The order denying the renewed DV after trial does incorporate the Prentice decision. But the case was...
Broad strokes, is it your position that this absolutely covers the situation, requires reversal, period?
Yes, Your Honor. Prentice requires that there be proof of statements that were received, believed, and acted upon. There is no evidence in this case that Mr. Giambalvo received statements from the tobacco industry that he acted on. The family members in this case were consistent in their testimony that they could recall no situation where Mr. Giambalvo talked about advertisements or statements from tobacco companies that he had received. There was the episodes where he talked about the filters and pointed to the filters and the discoloration of the filters, but the family members were consistent in saying they don't know where Mr. Giambalvo got that information. And this, I think, is
What do you make of the, I guess, the cousin's testimony? What's your take on that?
So that's Miss Dixon. Miss Dixon testified that in the 1960s, when they were about 17, they were living together for 3 or 4 months. They saw TV advertisements for Chesterfield, Philip Morris, and Camel cigarettes. There was nothing in her testimony about the statements from those advertisements. There was nothing that connected up later, any testimony from Dr. Proctor, who was plaintiff's expert on the alleged fraud and the conspiracy, and statements in those advertisements had a health claim. And importantly, under Prentice, it's not just a statement, any statement. It has to be a statement that's capable of causing the plaintiff, the smoker, to form a false belief about the health effects or addictiveness of smoking. So there's no testimony that the statements or whatever Mr. Giambalvo received back at that time was a statement that would even qualify. And there's no evidence that Mr. Giambalvo made a decision based on that advertising.
Well, the instructions were given in anticipation of Prentice, is that correct?
The instructions were compliant with Prentice. So Prentice holds that the jury must be instructed to find reliance on a statement. Those instructions were given in this case. But so the issue we're presenting is whether there was actually sufficient evidence to find reliance on a statement as to the conspiracy claim. Of course, the jury found for Reynolds on the fraud claim, found no reliance on fraudulent statements by Reynolds, but found reliance
It's
on...
no finding, actually made a finding that there was no reliance.
That's correct. That's correct. And importantly, I would point out, Your Honor, that the jury was instructed with a concurring cause instruction as to the reliance question for both conspiracy and concealment. So the jury was instructed that they could find a reliance on a statement by Reynolds, even if it wasn't it did not be the only statement. It could be a statement in combination with other acts or other statements. But the jury rejected that. The jury rejected that Reynolds' statements, either in combination or alone, was not the basis for Mr. Giambalvo's reliance. So that's why we are focused solely on the conspiracy claim.
But is your position under Prentice no inferences are allowed?
That is not my position, Your Honor. My position under Prentice is that the Martin inference, I'll call it the Martin inference from the first DCA's case that sort of started this in motion, which is there is sufficient evidence, a jury can infer reliance, the ultimate question from pervasive cigarette advertising. That has been overruled by Prentice. Prentice does say in the footnote that we're not deciding how these issues can be decided, so there can be inferences. I just want to point out three cases discussed in the briefs that I think illustrate what the evidence would look like. So in the McCall case, which is a fourth DCA case, the surviving spouse there testified that they had seen specific, she and her husband, had seen specific advertisements for Parliament cigarettes, that the filters of those cigarettes provided lower tar, lower nicotine. And then the smoker opened his filter and said, see, I'm getting lower tar and nicotine. Those were statements from an advertisement capable of forming a false belief about the health effects or addictiveness. That's a pre-Prentice case. In a post-Prentice case, Holloman, the third district, the daughter of the smoker testified that I was sitting with my dad watching nightly news programs, and we saw somebody from the tobacco industry come onto the news program and say, it's not proven that smoking causes disease. And then we had a conversation about that, and he says, see, cigarettes aren't harmful. So that's a specific statement from a member of the conspiracy, a tobacco industry spokesperson, that caused the belief. And then in the Cudahy case, and sort of getting to your question about what inferences would be permitted, the Cudahy case, Philip Morris case, the smoker there switched to Merit low tar, low nicotine cigarettes. The wife said he did that because it was a lighter cigarette. And the daughter testified that her father used language that was verbatim from the cigarette advertisements and explaining why he had switched. So it's not direct evidence that, I saw this ad that caused me to switch. It's an inferential case, but it's inferences that tie the smoker's decision specifically to a statement or a category of statements. And that's what we're missing here. Mrs. Giambaco, the surviving spouse, she sat at trial in this case, heard all of the testimony from Dr. Proctor. Again, that's plaintiff's expert witness on the question of the conspiracy to conceal. Dr. Proctor testified for 4.5 days. And we asked her at trial, you were here, you heard all of the evidence from Dr. Proctor about public statements that were alleged to conceal information about the health effects of smoking. Are you aware of your husband ever hearing any of those statements? And she agreed, correct, no, I'm not aware of any instance where he relied on such statements or even heard or saw such statements. And so we're lacking the kind of case-specific evidence tying statements to the smoker's beliefs and decisions in this case.
The federal case that came out, the Brown case, in the aftermath of Prentice, does that help your position?
Yes, Your Honor. It shows that if this...
The Marlboro Man?
Yes, that's the Marlboro Man. So that's the Marlboro Man general advertising campaign. I think the gist of that decision is Prentice requires a statement, merely, evidence of mere awareness of an advertising campaign without pointing to, well, what were the statements in those ads that caused you to form a false belief and continue smoking? That cannot be the basis for reliance. And importantly, the 11th Circuit had a previous decision, Coate, which had relied on the Martin inference and said, that's no longer the case. The Florida courts have changed, so we're not going to follow Coate any longer. So that's why this court, for example, should not follow this decision in Hallgren or Evers, which followed Martin, in allowing this inference of reliance based merely from pervasive advertising. And then, of course, the first district later in Whitmire said, and that's not what we said in Martin. That's not what we were doing. You can prove issues by inference, but you can't prove the ultimate issue of reliance through mere testimony of pervasive advertising.
It's odd, though, that the decades-long pervasive advertising in print, TV, etc., you'd have to be looking at the moon to have seen any of these things.
That is the testimony in the case, Your Honor. And there is testimony from, Mrs. Dixon that Mr. GMO saw these Chesterfield, Philip Morris, Camel TV advertisements. But the point is not that the point is the inquiry does not end with mere exposure to advertising. You have to show that he saw an ad. You have to show that he saw an ad about filtered cigarettes, or at least one capable of causing a false belief about the health effects or addictiveness of smoking. Seeing that advertisement and a statement in that advertisement, not just that he saw an ad, but a statement in an ad, approximately caused the false belief and the injuries. So at this point, we're stacking inferences to get from mere pervasiveness of advertising on the one hand, and the very specific question of reliance on the other hand. And remember, this is an Engel progeny case, and both Prentice, Florida Supreme Court, and the Whitmire First District decision were analyzing those issues in the context of Engel progeny cases. In Engel, generalized questions of the tobacco industry's conduct were decided in phase one. And the Florida Supreme Court said, well, we're going to have individualized issues decided in Engel progeny cases. Reliance is an individualized issue. It must be proven with individualized evidence. If it were the case that merely pointing to pervasive cigarette advertising and testimony that you had to be living under a rock not to see cigarette ads, and that's enough for reliance, then you're not actually having an individualized case in your progeny trial.
The other point you're making is kind of what we tried to do in the it's a generalization of exposure to all these different ads, and Prentice specifically called out our second ECA case and said, no, that's no longer the correct law.
And in fairness, the Dignan decision was half right. Dignan said there can't be reliance on silence. You know, silence is not enough, which we all agreed with, and of course, which the Florida Supreme Court agreed with. This court went a little further in Dignan to say, but if there's concealment as to a fact, a misapprehended fact to the smoker, that can be the basis for concealment. And that's what the Florida Supreme Court disagreed with. There has to be a fraudulent statement that causes the belief in the first instance. And this goes back to general principles. The argument by the plaintiffs in Prentice was that cigarette companies were advertising all the time and they never told the public of the risks of smoking. And the Florida Supreme Court said, if the belief is not caused by a statement in the first instance, it's pure speculation to say that additional disclosures later would have either been heard by the smoker or would have been given credence by the smoker. And so that doesn't count as sufficient evidence. Prentice was about what must be proven, but in calling that speculative, we know that that kind of evidence can't be the basis for a jury verdict. Speculative evidence doesn't count as competent, legally sufficient evidence. And so that's what we have here. All that we have are a parade of statements.
Simplistically, you can sort of say the Prentice stands for the proposition that the information has to be received, believed, and acted on. And this record doesn't so nothing factually indicate that that's the case here.
That's correct, Judge Black. So I think mine is a simple argument. I think the difficulty would be going through each of the laundry list of public statements that are cited in the answer brief and trying to connect those to Mr. Giambavo, because it simply cannot be done. There is nothing that connects Mr. Giambavo, for example, to white papers that were given to members of Congress and doctors. There's no evidence that Mr. Giambavo ever relied on a statement through any of those entities. There's just no evidence in this case to show that he relied, and we have the evidence from the family members. They're the ones, there were 6 or 7 fact witnesses who testified in this case, so it's not as if there wasn't, some basis for trying to decide the individualized issue. There were fact witnesses who testified about what he could have heard and what he could have relied on. There was no connection between his smoking decisions and any statement by a tobacco company. And, as we pointed out, there was abundant information during the 1950s through the 1980s from independent sources, public health sources, public service announcements, Reader's Digest, encouraging smokers to switch to filtered cigarettes. That didn't come from the tobacco companies. There's a suggestion in the answer brief that it all ultimately came from tobacco companies, but even Dr. Proctor on the stand acknowledged that at one time that was an honest view within and outside of the industry, that filtered cigarettes were a better alternative. And Reader's Digest was not a mouthpiece for the tobacco industry. Dr. Proctor described it as anti-tobacco from the 1920s. It ran ads against tobacco, but also encouraging smokers to switch to filtered cigarettes. So as to the belief about filters, not only would you have to infer that Mr. Giambavo saw an ad regarding filtered cigarettes or some other kind of statement about filtered cigarettes, but also that he did not receive information from public health community or other sources as the basis for his belief. If there are no questions about the photographs of the slides. I'm happy to rest on the briefs, but I'm also happy to answer questions about that. The basic,
You're down to about 5.5. You want to say 5 minutes?
I think I will save my time, Judge Fly. Thank you.
May it please the court. The first thing I would like the court to do when this is over, if I can ask that the court do this, is read Judge Muscarella's order on the very issues. It's the first 10 pages and it starts at 22,765 of the record. And read it, because what you will see, I hope, is that the case that was described to your honors that we tried was not the case that we tried. I understand counsel's arguments are based on cases that treat the prior way in which these cases were tried unfavorably. But I would point out to the court in response, direct response to Judge LaRosa's question, to look in particular at page 22,766 of the record. And this is from Judge Muscarella. She noted that we anticipated the ruling in Prentice. We agreed to instructions which predicted its holding, requiring reliance on statements. And this is a paraphrase, but more or less she says, that's how this case was tried. Now, we didn't come to this new. The lawyers who tried this case were involved in Whitmire, and the handwriting was on the wall long ago that the first district was going to abandon what counsel, I think, fairly calls the Martin inference. And we didn't try this case this way. And I want to give the court an example of something that requires no inference based on solely on direct evidence. It does require the court to accept our argument that the illusion of filtration, conduct that creates a false impression that cigarette filters work because they turn brown upon contact with smoke, which appeared in 1953 at the dawn of the conspiracy, that is the equivalent of a statement, a representation, what the Supreme Court of Florida at 338 Southern 3rd 383 calls the equivalent of a statement, one of myriad forms of conduct.
But does that boil down to an inference of harm?
No, I'm getting to
Not a
that.
generic inference of harm?
It's not a generic inference.
Where is the specific actual harm testified to?
The specific actual harm, looking at receipt, belief, and action, relates to the testimony of family members of Mr. Giambalvo, through whom he spoke at trial. They testified that when they confronted him about his cigarette smoking, when they said to him, the daughter, I learned at school cigarettes are bad. The son, cigarettes are harmful, stop. The wife, while he was in the act of purchasing cigarettes from a vending machine, please don't smoke. Remember, my father died of lung cancer. What did Mr. Giambalvo say? What did he say? They've had 80 pages of briefs and now 15 minutes of argument, and they haven't responded to this at all. What he said was, I see the representation, the brown stuff in the filter, and don't worry about me smoking because it's taking out all the toxins, all the bad stuff. They're keeping me safe. That's direct evidence of what he believed, direct evidence of his actions in response to concerns about his smoking, and direct evidence of receipt. How could he not have received the illusion that he is describing and demonstrating to his family members? 100% of that is not fairly responded to anywhere in the arguments. And that is the type of evidence that the courts consistently, without regard to any so-called Martin inference, have held is sufficient to get to the jury. They're not contending in this case that he believed too late, he believed too early, that it wasn't sufficient. All of those things that are contended very frequently in this litigation, they make none of those contentions. Their principal contention is that he failed, there was inadequate proof that he received any false statement. And all we are asking you to do with respect to this evidence, which requires no inference, because it's all direct, no inference stacking whatsoever, is to adopt the concept, which is a fair concept, that this is one of the forms, myriad forms of conduct. I looked it up. In Greek, it means 10,000, one of the 10,000 things that people can do to lie. And if you have any question about it, I urge you to look at what the Supreme Court relied on, what it relied on as an authority for this principle. It's section 106 of Prosser, the 1984 edition. And what does it say? It says something in substance what the Supreme Court said. Lots of things somebody can do to lie. And you know what? Interestingly, in a footnote, and it's footnote 5, it talks about a Michigan case where someone concealed that aluminum was rusty by putting unrusted aluminum on top, effectively making it look clean when it was dirty. And one of the gross ironies about the fraudulent nature of filtered cigarettes, what these defendants, or what the conspirators did, was make cigarette filters look dirty when they were clean. If that's not fraudulent, then nothing that is a form of conduct could be fraudulent. And it's very important because counsel says there's no evidence. It's true that the family members, most of whom were not with him at the relevant times when he started smoking, the one who was, his cousin, counsel makes it sound like they barely knew each other. They saw each other, according to unrebutted testimony, at least once a week until he was 16 and already a regular filtered cigarette smoker. So the suggestion is that's inadequate proof of what the ads said or what the ads were is just not a fair inference to be drawn in favor of them. There's direct evidence that he saw the ads. And the testimony from the family members, if your honors take a look at it in the transcript, these questions are always phrased the same way. Did your husband ever tell you what he was relying on? Did he ever tell you, I heard something from the Tobacco Institute and that's prompting me to act? That would be very unusual evidence. Counsel referred to 2 cases where there is similar evidence, but neither one of those cases require that. If a jury can draw an inference that a smoker believed what was being told everywhere, it is true that an inference is required in that instance, that there was, Judge LaRose, I think you referred to the testimony, that it was unavoidable. We're not trying this case on the theory that the evidence was, the stuff was out there everywhere, may have made the difference. We didn't try the case that way. But it is certainly fair that when a witness says it was everywhere and you could not have missed it, a different analogy, unless you were blind. The Federal Trade Commission in 1967 says you couldn't have missed it, impossible, because it was very concerned, guess what, that teenagers were caused to smoke by cigarette advertising, which blotted out all concern over the health effects and addictiveness of cigarettes. Those things do require some inferences, but as we argue in our brief, they are circumstantial evidence of permissible inferences that his beliefs were influenced at least, and that's the standard under Prentice, fairly read, by what the cigarette companies were saying and doing, and that those beliefs influence his actions. We know what they were saying. We know what they were saying. Cigarettes don't cause disease. It's a subject of controversy. The warnings are untrue. We know what Mr. Giambalvo believed. Cigarettes don't cause cancer. He told his wife that while buying cigarettes. The warnings are untrue, and it's not proven. We know what he believed. And the question is, was there sufficient evidence in the case to conclude, and I'm only talking about the evidence now that required an inference, the direct evidence about the illusion of filtration, to which they still have failed to respond. That's clear. But the question is circumstantial evidence sufficient to support a jury verdict with respect to these other types of very compelling evidence? I do want to say one thing about Whitmire, because we agree that just putting on evidence of the controversy and the advertising is not enough. And that's the important point of Whitmire. But we also know from Whitmire, and as it has been described, and I believe the pronunciation is Cudahy, by the First District, is that neither Whitmire nor Prentice prohibits the use of circumstantial evidence or the drawing of inferences. I think counsel very indirectly, but counsel conceded that in his argument. So the point is that here, unlike the other cases that it described, because we have learned our lesson, And we understand that the courts are saying the use of the word filter is not enough. I would submit that that is true, and we accept that. But that wasn't the only evidence in this case, because there was evidence, for example, at 20455, of the record, that the words, the quote, the word filter is present with its assurance that he, the smoker, has indeed shopped around for a safe cigarette. Can it really be contended that this smoker did not receive the message that his cigarettes were filtered? There's evidence, unlike in Whitmire, this is a quote from transcript page 2028, the very word filter means safer. And there was also evidence, for example, at 2004, that the deception was built into the design and the names of the products by calling them filters. But we didn't need just our expert to say so. If your honors take a look at a document that was essentially unrebutted, it is an important document in our trial. It is a memorandum written in the 1970s by a former general counsel of a conspirator whose name was Pepples, and he describes the history of the industry's so-called controversy. It's at 19457 of the record. He describes the history of the controversy, and that was the essential claim that it was unproven that cigarettes cause disease. And he describes what the industry did to promote the controversy. He has a list of things that were done in response. And the number one thing that they did, according to the former general counsel of a conspirator, was to make filter cigarettes. And that's at 19457. In the same document, a very important document, he goes on to say, simultaneously acknowledging that people are choosing these products on grounds of reduced risks to health. Other co-conspirators said the same thing internally in the 50s and 60s. There's examples of that in 18582 of the record and 19475. And so one of the things that's interesting about the defense position in this case is if you look at what the co-conspirators were doing, what they were saying about how smokers behaved and why they behaved the way they did. If you look at the evidence, you would have to conclude, and again, we're entitled to have the evidence viewed in the light most favorable to us, that in every respect, that Mr. Giambalvo was some kind of outlier. But it turns out to be the case that everything that he did and said and the way that he behaved in the light most favorable to us is exactly what they wanted and exactly what they intended. And if you think about it, going back to 1953, when this trick, the literally conjuring of an illusion, which we submit as the same as a representation, when that was first hypothesized as a way to trick smokers back in 1953. I'll have it for you in a second. And this is described in our brief. The person, a scientist from one of the conspirators who proposed this trick, what he says is, we've observed that when a filter turns brown, people, and this is a quote, automatically adjudge the filter to have been effective. And he goes on to say, well, we know that they don't do anything, but imagine the marketing potential for such a trick. And that's what happened in this case. That is the undisputed evidence, and no inference is required. No reliance on Martin is required. No consideration of the massive advertising campaign that dwarfed everything public health officials had to say about it is even required for this court to conclude that Mr. Giambalvo relied on the equivalent of a statement. And remember this, I think it's important. At the end of the day, Prentice says that what makes the requirement of a statement necessary is that these are commercial transactions. And that if you want to sue somebody for fraud, for selling you a product, then you have to identify representations, is the word I believe is used, that influence, at least in part, the Supreme Court tells us, their decision-making and actions. And we know what he did. There isn't any dispute about it, and we know why he did it. Because, as I mentioned, it was in response to concerns that he quit smoking. I want to say one thing about this idea that we have to show something that was done by a non-Engel conspirator. First of all, there is evidence that's incorrect for reasons I'll get to in a moment, in my view. But it's important to remember that at 2023, I believe it is of the record, with respect to the so-called illusion, all of the manufacturers did it, and that's at 2023 of the trial transcript. They all did it. Brown and Williamson, co-conspirator, sold him the Cools, they did it, in the light most favorable to us. Lorillard, when they sold him Newports, they did it in the light most favorable to us. And Reynolds, of course, they did it in the light most favorable to us when they sold him Winston. Now, why is it that it would be necessary in the context of this case, after Cudahy, unless the court disagrees with Cudahy, that a reasonable jury cannot conclude that the actions of the conspirators together is what made the difference? And remember, what this court said, or indicated, I should say, in Boatwright, is that the filter fraud was part of the broader conspiracy. It was part of what was being done to get people to keep smoking and not quit, even when the conspirators knew that they were harming themselves and becoming addicted. So one thing that we can see from the court, from the trial transcript, if you're concerned about how this case was tried, and if you contrast what the defendant actually told the jury about what the conspiracy meant, remember the case was divided into two phases, and after the case went to after the liability verdict was reached and the jury made its findings that have been discussed today, the parties had an opportunity to introduce evidence and arguments in support of or in defense of the claims for punitive damages. And counsel, my friend's colleague, this is what he told the jury their finding meant in phase one, specifically referring to the yes on conspiracy and the no on concealment. And so you're being asked to punish R.J. Reynolds when you made that finding in this case. What your finding means is that the conduct of Reynolds was not sufficient alone to cause his death. And that's exactly what Cudahy says, and that's exactly what we're saying. And the further proof that that's the way this should really work is the way they tried the punitive damage trial. They went on to have a witness that was a former executive of Reynolds. Did they talk about what everybody else did? No, they only talked about what they were doing now and how that was in mitigation of punitive damages. They gave examples of people who had made false statements in the past, who are now dead or gone, 4782. They gave examples of how Reynolds now tells the truth, making statements, obviously, about addiction and disease. And they even tell people to quit smoking, they claim. That's at 4758, 4784. They disclose their ingredients by brand, 4786 and 87. They turn over their research to the FDA, 4808. And this is important in light of the arguments made today. Today, this is what counsel for Reynolds told this jury in this case. And today, they do not, quote, communicate in any way to consumers that filters are less risky or dangerous. It was all about the statements that Reynolds is making today as compared to the statements they made in the past. Even though their corporate representative did say filters are safer, still he said.
Down to about a minute and a half.
The point, Your Honors, is that with respect to Cudahy, nobody should reasonably conclude, in our view, that the evidence in this case, the way this case was tried, required us to identify specific statements that were relied upon. It could have been any number of them, and as I mentioned, the evidence with respect to the illusion of filtration was essentially unrebutted. I do, Judge Black, want to say one thing about the Brown case. Holloman disagrees with Brown. It's a case that's subsequent to Brown with respect to whether or not specific statements have to be identified. And I think with respect to the 11th Circuit, and I know Judge Joe Flatt is a student of litigation, he once wrote a 200-something page dissent about the litigation. He says a specific statement has to be identified. The defendant in that case, which was Philip Morris, cited Brown as supplemental authority in Holloman. They don't mention it by name, but the third district didn't buy it, and I would suggest that Prentice is very, very clear on this point. There is no requirement that a specific statement be identified, and I think counsel indirectly conceded that.
You're technically out of time, but can you take 30 seconds? to
Yes.
just say-
And the one thing I would also like to say about Brown, the only evidence in that case about the advertising, and remember that was a living smoker case, the word filter doesn't appear in the opinion. If you search it, you won't find it, number one. The only thing that the living smoker could remember about the Marlboro ads was the red and white packaging and the cowboy. And she testified, and there was no other evidence apparently, that she didn't quit smoking, not because of any advertising, because she was quote unquote hard-headed. We don't have anything like that here, even if Brown was good law, which it's not in Florida. Thank you. We ask that
He's
you're,
going to go over the national.
yes, sorry.
So, you talked a lot about the representations and the whole body of information about the filters on the cigarettes. Is it your position that what has been put into the public domain, if you will, about the filter cigarettes complies with the requirements of Prentice?
I would say that, yes.
Received, believed, and acted upon, that there's,
yes,
you're already really focused on the filters.
right, because I'm equating a filter, the illusion
The filter
to,
meets these criteria.
is well, on the basis of the evidence in this case, which is that the illusion is a statement of a type. And I think Prosser and the Supreme Court recognize that. There's no question that it was received, to go through them, received by Mr. Giambalvo, because he describes his receipt of it and demonstrates it to family members. The belief is undisputed because he explains to his family members, consistent with the illusion that's created and what the industry wanted, what the brown stains mean. And there's proof of his action in reliance on his belief, because those conversations take place while he's buying cigarettes and defending against claims from his family that he should quit smoking. Did I answer your question?
Yes, sir.
Thank you.
You've got 4 minutes, I bumped it to 5. You took an extra minute, so theoretically, if you need another minute, you're entitled to.
Thank you, Judge Galante. So it looks like we're now focused on the issue of the color change of the filter and perhaps the word filter on the cigarette packs. Just want to point out that the first district in the Whitmire case expressly rejected those as the basis for a fraud claim. And in the Principe case, which is a third district decision, slightly different issue there. It's about the repose, but the court says in a footnote, the word filter is not inherently fraudulent. The cigarettes that Mr. Giambalvo smoked had filters on them. There's nothing inherently fraudulent about the word filter. As to both of these issues, I think the key thing is this. The jury on the fraud claim rejected reliance on a statement by Reynolds, even assuming this conduct of the filter is a statement, which I don't disagree, which I do not agree with. But even assuming it can be a statement, that was not a statement that was that could be the basis for reliance on as to the claim against Reynolds. It makes no logical sense to say that Mr. Giambalvo did not rely on the filters of the cigarettes he actually smoked, or the word filter on the packs of cigarettes he actually smoked, but he relied on filters of other cigarettes he did not smoke that changed colors, or filters on packs of cigarettes that he did not purchase. The evidence about a filter color change or the words filter on the pack, that would support a jury finding as to against Reynolds. But it does it all the more strongly against Reynolds. And the fact that the jury rejected that as the basis for the fraudulent concealment claim means it can't be evidence for the conspiracy claim. Mr. Sales talks about the Cudahy case where the first district noted appellant statements that could support the conspiracy verdict. Those were general statements that lower tar, lower nicotine, which were said by multiple members of the tobacco industry. And so they could gather strength from the repetition of the statement. But we're talking about the color change, which happens with the cigarettes that Mr. Giambalvo smokes, and the word filters on packs. We're not talking about filters in advertisement, like the word filter in an advertisement. This argument is based on the word filter on the packs, the ones that he smoked. Now, there were filtered advertisements out there We don't have any evidence that Mr. Giambalvo saw filtered advertisements. You'd have to have a further inference, not just from the pervasiveness of advertisements, that he saw a filtered advertisement. So you're stacking another inference. And this is key. Dr. Proctor explained that the filter advertisements was an implicit safety message. Recall, the conspiracy that was alleged and described was to stop trying to talk about health messages. More doctors smoke Camels. Don't do that anymore. Quit making health messages about smoking. So you wouldn't have a filtered advertisement that says filtered cigarettes are safer, because that would imply that non-filtered cigarettes are not safe. That would be a conspiracy violation, in the words of Dr. Proctor.
So to state the obvious, your information about filters does not satisfy the requirement of receive, believe, and act as a man.
That's correct, Your Honor. That's as the bottom line. And the suggestion, I think, from my opponent was that this was the source of Mr. Giambalvo's belief about filters. There's no evidence of that. The family members who described the episodes where he took the filter apart, we asked them, do you know where Mr. Giambalvo got this information? And they said, no, we don't know. Compare that to the McCall case, which I cited at the beginning. The surviving spouse said, we saw specific advertisements for Parliament cigarettes that they were lower in tar and nicotine because of the filter. And then he opened the filter and showed that that was the case. In these situations, he is being approached by his family members and said, we have concerns about your smoking. And he says, well, the filter's taking out the tar. He's not saying, well, let's look and see. And he pulls apart the filter and says, well, aha, the filter's taking out the tar. He already had this belief. He is using it to confirm to his family members his belief. So it's evidence that he had a false belief. It's not evidence that he received that belief from a tobacco representative. And there would have to be a further inference from filtered advertising, the word filter, because these were all implicit claims that Mr. Giambalvo understood the word filter to mean safer. What was recounted to you, I think, was clear from what my opponent said, but that was the testimony of Dr. Proctor. Dr. Proctor was an industry expert witness. He didn't know anything about Mr. Giambalvo. He said, filter means safer. There's no evidence that Mr. Giambalvo understood the word filter to mean safer.
You've used up to 5 minutes, but I said I'd give you 1 more minute. You want me to give you that extra minute?
Only to say that, and therefore, in order to make this connection from these very tangential notions about filtering, you would have to show that Mr. Giambalvo internalized that message, in the words of Whitmire. And that's a further inference that would have to be drawn that would prevent there being legally specific evidence to support the verdict. Thank you.
What remedy are you asking for?
I'm sorry, Judge
What
Black?
is the remedy you're asking for?
So we have asked for a complete new trial after this court's decision in Degnan 3, which is, there's not really a difference between that case and this case in terms of the facts, where this court limited the relief to judgment as a matter of law on the fraud claims, reduction of the compensatory judgment by the share of comparative fault, and then a new trial on punitive damages. So at a minimum, we think that is the relief that should be entered. The Prentice 1 decision did grant a complete new trial, and I would say about that only that this court has appellate discretion. It's always been recognized that appellate courts have discretion to grant complete new trials. There's some limitations on when they can grant partial trials, but the court has discretion to grant a complete new trial. I don't disagree with what the Degnan 3 court said, the other panel members of this court, but it was based on the sequencing of the verdict form.
Did you answer the question?
Yes, Your Honor.
But you're out of time.
Thank you, Your Honor.
Thank you.
Yes.
Gentlemen, well done. Thank you.
Very
Thank you.
good job, guys. Thank you.
Moving on to Abrahamian, American citizen. Ready for